All right, Commissioner O'Donnell, just making sure you're still with us.
Yes, sir.
All right, thank you. Morning. This hearing is called to order. I am Commission President James Brown. I am the presiding officer for this hearing. With me today in the Bollinger Room are Vice President Jennifer Fielder, Commissioner Randy Pinocci, Commissioner Annie Bukacek. Commissioner Tony O'Donnell is participating remotely via video conference. Staff attorneys Lucas Hamilton and Dan Palco will be advising the commission during this hearing. Additional commission staff will also be present. This hearing is being transcribed by our court reporter with Lazowski Court Reporting. Please identify yourself. Hi, Ollie. Good to see you. I would just note, of course, that if the hearing, we will be taking breaks during various portions of this hearing, and we will go off record, and then we will, of course, come back on record. So for the record, the time is now 9:13 a.m. I apologize for the delay this morning. We did have a legislative work session this morning that went a little long. Date is Monday, February 27, 2023. The commission and staff are appearing from Helena, Montana in the Bollinger Room of the Montana Public Service Commission. This is the scheduled public hearing in docket number 2019.10.076 involving the petitions of CED, Wheatland, Teton, and Pend Oreille to set terms and conditions for a qualifying small power production facility pursuant to MCA 69-3-603. This hearing, of course, concerns issues on remand from the Montana Supreme Court. And as the presiding officer, I expect that all involved will focus only on the issues on remand. And what I mean by that is I don't expect a 3-day hearing. Counsel. I will now take appearances of counsel. Please introduce yourself and who you represent for CED.
Lowell Chandler, CHANDLER, Uda Law Firm representing CED.
Michael Uda Law Firm, also representing Consolidated Edison Development. I'm not sure she's going to make an actual appearance, but she is here. Anna Keshkesh, also from the Uda Law Firm.
Mr. Uda. Brown.
Good morning, Mr. Chairman, Commissioners. Please enter the appearance of Jason Brown, on behalf of the Montana Consumer Council.
Good morning, Mr. Chairman, Commissioner. Sarah Norcott on behalf of Northwestern Energy.
Thank you. Good morning, council. Again, recesses will occur at convenient times during this hearing. One of the curiosities of our contested case proceedings is that we do seek public comment or allow opportunity for public comment. So I'll ask, are there any public commenters in the room this morning? Seeing none, is there any public commenters online? Seeing none. All right. Are there any informal questions or matters from the parties before we begin today's evidentiary hearing?
Mr. Chairman, if I may, in Northwestern's pre-hearing memo, we had asked that if there are questions for Mr. Michael McGowan, that he be able to appear by Zoom. As I understand it right now, there are not questions for him, but if during the course of this proceeding questions do arise, we would still ask that he be able to appear by Zoom. Thank you.
It's my understanding this is unopposed, but Mr. Uda, no objection. Mr. Brown. All right, the request is hereby granted. Any other matters? All right. Let's address some of the pending matters before the commission at this point in time. As the council are aware, as the presiding officer at today's hearing, I have the authority under commission rule to decide non-dispositive motions and objections. As such, I will address each of the matters that are pending before the commission in order. We did grant the request to allow a witness to testify remotely, of course. We will address Northwestern's pre-hearing objections to a data response and administrative notice. We'll address the motions to admit data responses, the motions to take administrative notice, and Northwestern's motion to strike. Okay. Northwestern's written objections. Northwestern's pre-hearing memo objected to a data response and a request for the commission to take administrative notice. Ms. Norcott, I will give you the first opportunity to speak to your objections. You may address them one at a time or all at once. What is your preference?
Mr. Chairman, one at a time would be preferred.
Okay, please proceed.
Thank you. In Northwestern's, as the chairman noted, pre-hearing memo, Northwestern did object to the identification of one data request being admitted into the record. And in fact, it's not the entire data request, it's just a portion of the data request. And Northwestern's objection to that portion of the data request is because it contains alleged testimony from a person in an Oregon docket who is not a witness in this case. And there are two reasons that this testimony cannot come into the record. First, it's a violation of the Montana Constitution and the Confrontation Clause. Northwestern has not had an opportunity to cross-examine this individual, and that is a violation of the Montana Constitution. Secondly, this particular data request and this evidence, alleged testimony, is objectionable because it is hearsay. This individual it's being offered, hearsay is inadmissible as it is a statement made by a non-witness that is offered into evidence to prove the truth of the matter asserted. There is no explicit exception to the testimony being admitted in this case. The data request is being moved into evidence by CED to prove that another person agrees with their expert's opinion about direct assignment of network upgrades. This testimony is clearly hearsay and is inadmissible. And for these reasons, Mr. Chairman and Commission, Northwestern objects to the portion of data request NWE R13B. Thank you.
Yes, if I may.
You may.
Mr. Chairman, Commissioners, so just a little bit of background here on this data request. Northwestern requested information on how Oregon's policy on network upgrades was impacting QF development. Naturally, our expert looked to proceedings before the Oregon Public Utility Commission and found this ongoing proceeding, docket 2032, where the expert, Mr. John Lowe, provided his expert testimony in an official proceeding, an official document filed in that proceeding. And as the commission knows, we routinely rely on expert information under in these proceedings. The Montana Rules of Evidence, Rule 702. If the scientific, technical, or specialized knowledge, excuse me, will assist the trier of fact, the expert may testify to that information. That's what this quote from John Lowe is. It's an expert information, and our expert relied on that information to answer Northwestern's request. Mr. Schiffman is not adopting that testimony as his. He's just relying on that other expert testimony to support his opinion on the issue. And I would note that I would say that there is an exception here, Rule 803, the public records exception. This was testimony filed, official testimony filed in response or before the Oregon Public Utilities Commission, officially noticed. And even if the public records exception were not to apply, Rule 803 subsection 24 has a catch-all that discusses the exception applies where circumstantial guarantees of trustworthiness exist. This is an expert testifying on the situation in Oregon. I think this is admissible. And I would also reiterate what Ms. Norcott mentioned about it's not the entire data request if the commission does decide to strike the portion of mentioning John Lowe's, since Mr. Schiffman did the second half discussing PacifiCorp's interconnection queue is should remain because that's Mr. Schiffman's own research and personal knowledge. Thank you.
Mr. Brown,
No comment. Thank you, Mr. Chairman.
did you want to respond?
Yes, thank you, Mr. Chairman. First of all, recall that this is a discovery request and the rules of discovery are broader than the rules allowing evidence into the record in this case. Northwestern did ask, quote, "Are you aware if your claims about direct assignment have come to fruition in Oregon where QFs had paid for network upgrade without reimbursement?" I would submit to the commission that Mr. Schiffman has gone beyond that question and provided testimony of a third-party non-witness in this case. Mr. Lowell, in his response to this objection, did not in any way disagree that this is a violation of the confrontation clause. Northwestern has not had the opportunity to cross-examine this individual about his claims. For that reason alone, this data request is objectionable and this information should not come into the record. As far as the other claims in the exception for the hearsay, as far as 804, Rule 804, the Montana Rules of Evidence, and this idea that this testimony has some type of trustworthiness around it, recall that in Rule, 804 also talks about if a witness is not available, that the party needs to show that that witness is not available, and then former testimony or other testimony can come into the record. Testimony that is in a different docket, again, that Northwestern has not had the opportunity to cross-examine, is not admissible and should not be admitted. Thank you.
All right, I'm prepared to rule. I'm going to sustain Northwestern's objection to the admission of the quoted material in NWE-R013B. I find the material is inadmissible under Montana Rule of Evidence 611E and 802. Did we want to discuss the Northwestern's objection to taking administrative notice of the second day of the job own transcript?
Yes, thank you, Mr. Chairman. Northwestern does object to the commission taking administrative notice of day 2 of the hearing in the job own docket and the transcript related to that particular hearing. The commission is permitted to take judicial notice of cognizable facts, and that's in Montana Code annotated 2-4-612 subpart 6. This, though, extends only to facts that are not disputed, and that's under Montana Rule of Evidence 201B. The purpose of this mechanism is so that parties don't have to spend time talking about facts that aren't disputed. For example, the commission could take a judicial notice of the fact that the sky is blue. That would save the parties from having to enter into evidence facts that the sky is in fact blue. Everyone agrees that the sky is blue, so the commission could take judicial notice of that fact. CED has asked the commission to take administrative notice of an entire day of hearing in a different docket. This transcript is saturated with disputed facts, and therefore it's inappropriate for the commission to take administrative notice of the entire day of the transcript. In fact, the commission has previously denied such a request in this very docket when CED asked the commission to take administrative notice of the Teton and Pend Oreille hearing that had occurred before the Wheatland hearing. And in the Wheatland hearing, the commission denied that request to take administrative notice of the Teton and Pend Oreille transcript. While Northwestern does not dispute that CED can use portions of the transcript, they cannot just carte blanche move that into the record and have the commission take administrative notice of it. There are other evidentiary tools if they would wish to use it, but this is not the appropriate tool. And for that reason, Northwestern objects.
Response?
Thank you, Mr. Chairman. I would just note that Rule 201 of the Rules of Evidence provides that a fact that is capable of accurate and ready determination by resort to sources whose accuracy cannot be reasonably questioned. That's the definition of judicially cognizable fact. So is Northwestern questioning the accuracy of Lasofsky's court reporting in the jawbone hearing? Because I'm unclear on what a better judicially cognizable fact is than an official transcript from a hearing. I think it's proper for the commission to take notice of the jawbone transcript and what was said in that document, the words stated by the witnesses there. Northwestern's not, I assume Northwestern isn't disputing the transcript from that. So we're just asking for notice of the transcript.
Mr. Brown?
Mr. Chairman, I don't have a position on whether the commission should take notice or not in this case, but I would say if the commission does take notice, it's generally safer and better policy to just take notice of the whole transcript and the entire hearing rather than potentially letting parties cherry pick just a piece of it. So I would see the whole transcript. I forget how many days that was, but as it's kind of a single document. So thank you.
Ms. Norcott?
Thank you, Mr. Chairman. I will reiterate. The commission can take judicial notice of undisputed facts. This case, this transcript, excuse me, there are, yes, it is an accurate record of what happened in Jawbone, does not mean that it's something that wasn't disputed at the time, that wasn't decided at the time. Again, I reiterate, and I haven't heard anything from counsel that this is permissible. I'm not aware of any case law that supports the idea of a court taking administrative notice or judicial notice of an entire transcript from a different hearing under this rule of evidence. So for those reasons, again, Northwestern objects.
All right, I'm prepared to rule. I find Northwestern's argument to be persuasive. Therefore, I will sustain Northwestern's objection to taking administrative notice of the second day of the Jawbone transcript. I note, however, my decision only extends to administrative notice. CED may move for the omission of that transcript after laying foundation with the witness and use the transcript for proper impeachment purposes. All right, let's move on to the admission of data responses. CED's pre-hearing memo indicated it would move to admit all responses and associated exhibits. Therefore, I would entertain a motion from Mr. Uda or counsel to admit all data responses that were not the subject of a sustained pre-hearing objection. Would you like to make that motion?
Yeah, we would motion to admit all data requests and responses.
Is there an objection?
Mr. Chairman, just so the record is clear, I think that you indicated as much, but just make sure the motion is clear that it's all data requests that have not been excluded or had the objection sustained.
I think that's probably the intent of the motion, Mr. Brown. All right, seeing no objections. All data requests that were not the subject of a sustained pre-hearing objection are admitted into evidence at this time. All right, let's move to discussing administrative notice. CED's pre-hearing memo asked the commission to take administrative notice of a variety of documents other than the Jawbone transcript. Would you like to make a motion at this time?
Yes, thank you, Mr. Chairman. We would motion to for the commission to take administrative notice of all the documents listed in CED's pre-hearing memorandum.
Ms. Norcott, is there an objection?
No, thank you, Mr. Chairman.
Mr. Brown? All right, hearing no objections, commission will take administrative notice of the documents listed in CED's pre-hearing memo, with the exception of the Jawbone transcript. All right, next, Northwestern's pre-hearing memo indicated it would introduce interconnection studies for project 420. Ms. Norcott, would you like to make a motion at this time?
Mr. Chairman, I don't believe I need to. That particular project and its interconnection studies was just taken administrative notice of in CED's motion. So it's already in the record and that should suffice for our purposes. So not at this time. Thank you.
Do other council agree? Very
No
good.
objection.
Move on then. All right, finally, let's move on to Northwestern's motion to strike. This matter is fully briefed and does not require further argument. Having reviewed the party's briefing on this matter, I will grant Northwestern's motion to strike. I have prepared a written order reflecting my decision, and I will now ask the commission staff to circulate that order to the parties. In addition to providing copies to the parties, the commission will post this ruling to Eddie. Please give a copy also to our transcriptionist. I think what we'll do is take a brief recess to allow the parties to review my written order. The time is now 9:32 a.m. We will reconvene. How about 9:50? And with that said, we are now off the record. Commissioner O'Donnell, you still on?
Yes, sir.
Okay, thank you. We are now back on the record. Time is now 9:50 a.m. Are the parties prepared to proceed? I understand that we may have some discussion about data requests. Ms. Norcott?
Thank you, Mr. Chairman. In light of the ruling to strike testimony related to the avoided capacity cost calculations, there are data requests that the commission has moved into the record that relate to that issue, and I apologize for not flagging that in the motion. However, there are two that I have identified that should be not included given the ruling on the motion to strike, and that would be NWER 006, which very specifically discusses the avoided capacity calculations, and CED R40, which again is talking about the appropriate proxy resource. So with that, Mr. Chairman, I would move the commission to reconsider the inclusion of those two data requests into the record.
Mr. Chandler?
Yeah, if I may, can I review those data requests that were just mentioned?
Yes, please take your time.
if I may, just get some clarification. Was the second one CDR 40?
Yes.
Yeah,
Mr. Chandler.
Mr. Chairman, Commissioners, so I would just note that there was no mention of these data requests being struck along with her original motion to strike. If there were, we would have more of an opportunity to respond rather than kind of be surprised here at the hearing. In relation to CDR 40, that one definitively discusses also avoided cost of energy, appropriate proxy generally, as well as the use of Yellowstone County Generating Station. And yeah, and I mean, in terms of the ruling after review, I just would like to clarify that the ruling itself, if I may, while the proxy methodology was used by the commission after the close of the record evidence in the original proceedings, the ruling specifies that CED and Mr. Schiffman is barred from discussing the proxy methodology in relation to the proper proxy used for avoided capacity costs, but not avoided energy, correct?
So let me address, before we go there.
Yeah.
Let's address the motion in Northwestern Energy. I understand your argument, Mr. Brown.
Mr. Chairman, I don't have any comment. Thank you.
Just briefly, Mr. Chairman, on CED R40, this specifically asked about Mr. Schmidt's rebuttal testimony. And in light of the ruling, Northwestern will not be moving Mr. Schmidt's rebuttal testimony into the record because it dealt solely with the avoided capacity calculation. So therefore, if the testimony isn't in, the data request should also not come in.
All right, so first of all, let me apologize to council on behalf of the commission for any confusion that the order I address motions may have caused. I'm going to overrule your motion to strike. The data requests are in the record at this point. To the extent that they become an issue, if you will, we can address those at the time that they're used with the witness. So I will overrule that motion now. Mr. Chandler, did you want to address the matter that?
Yes, Mr. Chairman, I just want to get clarification so that we're clear moving forward the effect of this order. It's in relation to solely proper proxy unit use for avoided capacity. CED may continue to argue in relation to the proper proxy for avoided energy.
Your understanding is correct.
Thank you.
Any other matters? Again, I apologize for any confusion. All right, are there any other formal pre-hearing matters such as requests for accommodating witnesses, stipulations, or evidentiary motions? Seeing council all wave off. Let's move to opening statements by the parties. I understand that the parties have agreed that Northwestern will present first today. Is that correct?
That is correct.
You. Would you like to move to make an opening statement then?
Yes, thank you, Mr. Chairman, Commissioners. Good morning again. We are here today because the Montana Supreme Court decided that a qualifying facility, or QF for short, who causes significant and necessary upgrades to Northwestern's transmission system should not have to fund the entire cost of those upgrades. There are three main issues that you will hear about today. First, the allocation of the network upgrades for the Wheatland project from Consolidated Edison, or CED for short. Second, refund of all network upgrades to CED for all 3 of its projects. And finally, the requirement to provide full security regardless of the allocation of network upgrades. These issues all have one thing in common. If you accept CED's evidence as you hear it today and tomorrow, potentially, it will be a windfall for CED to the detriment of Northwestern's customers. This will harm Northwestern's customers through higher costs. So turning to the network upgrade issue. So while the Montana Supreme Court's decision seems to fly in the face of the concept within federal law that customers must remain indifferent from the purchase of power from a qualifying facility, Northwestern has presented a methodology that the commission can utilize to assign and allocate these network upgrade costs to CED for its Wheatland project. The evidence in this case will show that Teton and Ponderay must pay for their entire network upgrades, as these upgrades do not add new transmission capacity to Northwestern's system. Stated differently, these 2 projects are only necessary for the interconnected operation of these projects and do not add value to the transmission system for other customers or other QFs to use. As it relates to the Wheatland project, however, the evidence will show that the upgrades required that Northwestern must make for Wheatland's interconnected operations result in 90 megawatts of new usable and reliable transmission capacity. It will show that it will show that Wheatland will need 75 megawatts of that 90 megawatts, and thus should be responsible for 83% of the network upgrade costs. Contrast that to the evidence you'll hear from CED, who believes that their allocation should be in the range of about 15% of those costs. Recognizing that whatever they don't pay, other customers will have to pay. The evidence presented by Northwestern will show that while Northwestern must build a new partial 230 kilovolt or kV transmission line for Wheatland's interconnected operations, this new line does have limited capacity and transfer capability unless other upgrades are made on Northwestern's system. These other upgrades are not proposed to be made in this case because they are not necessary for Wheatland's interconnected operations. The evidence will show that while this new partial line will have a certain thermal rating, this rating does not equate to the amount of megawatts or the transfer capability of that line. This new line, if built, doesn't operate in isolation from the rest of the system. It must be considered with the rest of the system. And because of that, the rest of the system has limitations, and thus it limits the transfer capability of a new partial 230 kV line. A helpful analogy to think about this evidence is a watering system. On that watering system, you have 2 hoses. One has a 2-inch diameter. The other has a 4-inch diameter. The 4-inch diameter hose breaks, sending energy onto the 2-inch diameter line. Given the size of the 2-inch diameter, it's unlikely it's going to be able to take all of that water from the 4-inch diameter, which would cause potentially the 2-inch diameter line to break. Northwestern's transmission system is similar, as the evidence will show. If this larger transmission line is limited, energy will be diverted elsewhere. This diverted energy onto the smaller system is likely to cause overloads. The bottom line is Northwestern, as the evidence will show, can only move 90 megawatts over this new transmission line without spending more money elsewhere on its transmission system in order to accommodate more energy and ensure that these overloads do not occur. All the evidence in this case that will be presented will show these facts and will show that more money will be necessary in order to alleviate these overloads and maintain system reliability. Turning next to refunds. This evidence will show that if the commission agrees with CED that it is entitled to a full refund of all network upgrade costs that it pays for all three projects, CED will pay nothing. Let me reiterate that. If the commission agrees with CED about the evidence they're about to hear, CED will pay $0 for the network upgrades. This would be contrary to both PURPA and the Montana Supreme decision. And the evidence will show that QFs are not transmission service customers. Thus, they do not pay transmission service rates. The evidence will show that non-QFs who are transmission customers pay transmission service rates. And as such, they are entitled to a refund because they will pay for those upgrades through the payment of transmission service rates. If they don't receive a refund, they will be paying twice. The goal is to only collect these costs once. And if CED, as the evidence will show, because they don't pay transmission service rates, pay upfront, but then get a refund, they will not pay at all, not even one time. Turning to the final issue, security. The evidence will show that QFs should have to provide the full amount of security for the network upgrades, irrespective if there is an allocation that they may only ultimately be responsible for something less. If the QF, the evidence will discuss and show that if the QF walks away from the completion of these upgrades, those upgrades are beneficial to no one. And Northwestern's customers should not have to pay for the QF's decision to walk away. The QF should be on the hook for upgrades that aren't completed and hence the full security, not customers. And so that with that, Northwestern's witnesses here today will present this evidence. Mr. Michael Cashel will discuss Northwestern's policy considerations supporting the payment of network upgrades without a refund. Mr. Thomas Pankratz will discuss Northwestern's determination of the 90 megawatts of new usable and reliable transmission capacity related to the Wheatland project. Ms. Autumn Moeller will discuss the allocation methodology and the requirement for full security from QFs. And finally, Mr. Stephen Schmidt, although I didn't identify it in my opening, will discuss how the commission's proxy calculations determined originally were reasonable and appropriate. We are here today to help you understand this evidence. So I urge you to ask questions if something is unclear. And I thank you for your attention. With that, Mr. Chairman, I will call my first witness.
I'd like to give Mr. Chandler the opportunity to do the opening statement now or to reserve. Or Mr. Uda.
Mr. Chairman, I assume we're calling you chairman when you're
Yes, Mr. Uda.
been having a problem with this. for a
Yes,
while.
yes, you have.
I know, I'm struggling. Anyway, yeah, we're going to reserve before our case in chief.
Very good. Mr. Brown.
I'll do the same. Thank you, Mr. Chairman.
Okay, before you proceed, I do have a clarifying question, and I'm going to start with you on this one, Mr. Uda. So I've read through the pre-hearing memoranda, and I'm wondering to what extent the avoided cost of energy calculation is a contested case issue in this matter, still to be decided by the commission.
As understand the proxy that our expert relied on is different from the commission's proxy that was used.
Ms. Norcott, do you agree?
I do agree with that, Mr. Chairman. I would note that Northwestern did not take issue with CED's calculation of avoided energy. We did take issue with the capacity, but not the avoided energy.
So what I'm trying to drill down, is this in dispute or no?
From my perspective, I would say it is not a disputed issue. In our pre-hearing memo, we did not identify avoided energy as a disputed issue because we did not file testimony on it. So we were comfortable with, even though it was a different proxy, it did increase the avoided costs of energy slightly, about 50 cents or so, but we did not take issue with that.
Before I go back to you, Mr. Brown, do you have anything to offer here?
Mr. Chairman, I think you know, the legal question of the scope of the remand should be something parties can address still in post-hearing briefing. But I don't have anything else to add regarding what's been said already. Thank you.
Mr. Chandler.
Mr. Chairman, so I did get some clarification from our expert. The proxy unit itself is the same, but the heat rate degradation factor is different.
You agree?
Mr. Chairman, I do agree with that.
We'll move forward then. All right, Ms. Norcott, please present your case, Chief.
Thank you, Mr. Chairman. With that, Northwestern calls Michael Cashel to the stand.
Mr. Cash. Good morning. All right, so we all know the drill at this point in time. I would ask that all of today's witnesses to please stand, raise your right hand, and I will swear you in all at once. All right, do you swear the testimony you're about to give is the truth and nothing but the truth? We have affirmatives, I think, from everybody standing in the room at this point. Thank you. Again, counsel, if any of your witnesses are not present today, please notify me now. And at the time your witnesses are called to testify, so I may swear them in at that point in time to provide testimony. Okay. All right.
Thank you, Mr. Chairman. Mr. Cashel, would you please state your name, spelling your last name, and your business address for the record?
Yes, my name is Mike Cashel. Spelling of my last name is Cashell, and my business address is 11 East Park, Butte, Montana,
And by whom are you employed?
Northwestern Energy.
And would you please provide the commission with your title at Northwestern Energy?
Yes, my title is Vice President Transmission.
Mr. Cashel, did you submit pre-filed direct testimony in this docket?
Yes, I did.
And placed before you is a document that has been marked for identification purposes as Exhibit NWE1. If you would take a moment to review that and indicate when you are done. Is Exhibit NWE1 a true and correct copy of your pre-filed direct testimony?
Yes, it is.
And if I were to ask you here today under oath, the same questions that are set forth in Exhibit NWE1, would your answers be the same except for any corrections or modifications?
Yes, they would.
Do you have any corrections or modifications that you need to make to this exhibit?
No, I don't.
With that, Mr. Chairman, I move for the admission of Exhibit NWE1.
Mr. Ruder, Mr. Chandler?
No objection.
All right, Mr. Brown, no objection. NWE1 is so admitted into the record.
Mr. Cashel, did you submit pre-filed rebuttal testimony in this docket?
Yes, I did.
Again, placed before you is a document that has been marked for identification purposes as Exhibit NWE2. You'd take a moment to review it and let me know when you've finished.
I'm done.
Is Exhibit NWE2 a true and correct copy of your pre-filed rebuttal testimony in this docket?
Yes, it is.
And if I were to ask you here today under oath, the same questions that are set forth in Exhibit NWE2, would your answers be the same except for any changes or modifications?
Yes, it would.
Do you have any changes or modifications that need to be made to this exhibit?
No, I don't.
With that, Mr. Chairman, I move for the admission of Exhibit NWE2.
Mr. Chandler?
Yeah, if I may, Commissioner, we don't have an objection, of course, but in terms of how we label the exhibits, do we want to have a different identification since we're in a remand? Maybe an R before the number or? But then it matches the data request too, so.
Mr. Chairman, that is a good point, as we are still in the same docket. If it does make sense, we could revise our exhibit numbers to be Exhibit NWE R1 and NWE R2, if that would be amenable.
Yep, makes sense.
Mr. Brown? Yeah, I think that probably does clarify the record. So without objection, it's so ordered. And I think you had moved for admission, and then was there objection to admission?
We have no objection.
Thank you, Mr. Brown. All right, NWRE 2 is admitted.
Sorry, Mr. Chairman, just exhibit NWE R2.
R2. Thank
Correct.
you.
Okay.
Sorry.
Mr. Cashel is now available for cross-examination and questioning.
Very good. Who will be handling this witness?
I will be.
All right, please proceed, Mr. Uda.
Can you please turn to your, turn to CED RO 40. Are you there, Mr. Cashel?
Yes, I am.
Go ahead, Mr. Uda.
On A, you were asked to please provide any and all references where the Federal Energy Regulatory Commission has articulated the policy you claim in your testimony, including citations to FERC rulings and paragraphs in such rulings. Policy. That
You're referring to R041A?
Yep.
Yes.
and your answer, without going through the whole thing, generally refers to pages 133 through 151 of FERC Order 2003. Is that correct?
Yes, my answer refers to those generally and then very specific paragraphs as well.
Understood. I wanted to ask you about that because in that string citation between pages 133, 151, FERC stated on paragraph 696, however, the commission remains concerned that when the transmission provider is not independent, it has an interest in frustrating rival generators, the implementation of participant funding, including the quote, but for pricing approach, creates opportunities for undue discrimination. And I believe in paragraph C of your response, or RO41C, you specifically talk about poor siting decisions made by the QF. Is that correct?
Read my response, please.
Sure.
I do cite that. Yes.
Further on in paragraph 696 of FERC Order 2003, FERC states, as the commission stated in the NOPR, Notice of Opportunity of Public Rulemaking, a number of aspects of the quote, but for approach are subjective, and a transmission provider that is not an independent entity has the ability and the incentive to exploit this subjectivity to its own advantage. Let me ask you this question. Is Northwestern, as FERC would define it, an independent entity?
Mr. Chairman, I'm going to object to the reading of a FERC order and then actually not asking questions about that FERC order. He's assuming facts that aren't in evidence, and he hasn't asked the witness if he agrees with those positions.
I don't understand the objection. I'm laying a foundation for the questions to follow.
I'm going to overrule.
Hey, Mr. Cashel, do you recall the question I just put to you? Is Northwestern an independent entity as FERC defines it?
I believe your question is asking whether or not Northwestern is an independent entity like an RTO.
Right.
Is that your question?
Yes.
No, we are not an independent RTO type of entity. We are a transmission provider.
Okay, so Northwestern as a company both builds generation, owns generation, and owns the transmission and distribution system. Is that correct?
That's correct.
Okay. FERC goes on to state For example, such a transmission provider has an incentive to find that a disproportionate share of the costs of expansions needed to serve its own power customers is attributable to competing interconnection customers. Do you agree that that could be a risk?
Well, FERC cited that as a potential risk. I do not believe that that's the situation we're facing here today.
You don't believe that it applies to Northwestern?
It certainly does not apply to Northwestern as it relates to your specific project and your question.
Mr. Ruda, can I stop you for a minute? What are you reading from at this point in time?
This is FERC Order 2003, paragraph 696.
All right, thank you.
Paragraph 696 continues, Commission would find any policy that creates opportunities for such discriminatory behavior to be unacceptable. Can you identify for me where FERC policy is talking here about protecting Native customers?
So I don't have the entire orders in front of me, but the FERC policy, the pricing policy associated with independent generators and FERC orders 2003, 2006 clearly lays out several fundamentals. One of them is to assure that native load customers and other customers under the OATT are not harmed when it comes to interconnection of a third-party generator.
Sure. And one of the other policies they mention here is not allowing non-independent utilities to use the but-for test to use that discretion to allocate inappropriate costs to independent generators, correct?
I disagree that we're using a but-for test. We've gone into very great detail in our modeling to determine what is necessary to interconnect all three of these projects. Wheatland in particular causes significant upgrades on our system. And in fact, if you look at that area specifically, the reason that large upgrades are necessary is because of a large interconnection queue and also senior projects, generating projects, most of them qualifying facilities want to or have interconnected to that portion of the system.
Okay. But can we look at your response to 41C, specifically starting with the sentence that begins furthermore? Can you read that to the commission?
Sure.
Please do
I
so.
can. Furthermore, Northwestern's retail and other OATT transmission customers under Mr. Schiffman's advocacy would pay for the poor siting decisions made by the QF. These siting decisions in many cases result with significant network upgrades because the QF has no incentive to make siting decisions that recognize the cost of network upgrades.
Okay, when FERC was discussing the but-for test advocated for by utilities during the 2003 rulemaking proceeding, weren't they making that exact same argument?
So again, I don't have the order in front of me, but I believe very strongly that we are not putting Wheatland in a situation that is discriminatory in this case. And we are not suggesting that costs that we've assigned to Wheatland are arbitrary. They are real and associated with the interconnection of that facility.
Okay, but what's the difference between the but-for test as described in the FERC order and your poor siting decision language?
Can you restate the question? I'm not sure I followed it.
Okay. In your answer to 41C, make specific reference to poor siting decisions, correct?
And so does FERC in their pricing policy.
Okay.
The reason that the QF non-independent generator is required to pay upfront for the generation interconnection costs is in part to incent good siting decisions on the part of the generator.
Right, that's
Before you ask your next question, Mr. Cash, can you pull your microphone?
A little closer.
And then Mr. Ruda,
where that no one online can hear.
and you as well, Mr. Ruda, can you pull the microphone closer?
Yeah, sure. Nobody's ever accused me of being too quiet before. Mr. Cashel, so that was a good answer, but it didn't really answer the question I asked. What's the difference between FERC's but-for test and your poor siting decisions language?
I'm not sure that I can answer your questions. The order is very clear about part of the incentive requiring an independent generator to pay for network upgrades up front is to ensure proper siting decisions. That's clear in the order.
But if you can't describe for me what the difference is between FERC's concern about the but-for test and your poor siting decisions test, how do I know you're not just doing that?
Well, I'm not an attorney, so I can't opine as to the but-for test versus the language regarding good siting decisions. But what I can say is that all of the study work that we employed for all of the different generators that have requested interconnection in that area has been consistent, and we have consistently found that significant upgrades are necessary in that area. And there's a really simple reason for that. That area is a sparsely populated portion of Montana with a series of interstate highways running between large cities, and then also smaller secondary highways in terms of the transmission system that support relatively small load. Now the transmission system has been asked to support very large amounts of generation interconnection, which simply under contingency conditions overruns the transmission system. That's why our upgrades are significant.
Okay. I understand your position. The next sentence in paragraph 696 says, furthermore, none of the commenters in this proceeding has convinced the commission that in the absence of independence, it is possible to implement a quote, but for pricing approach that avoids this inherent subjectivity. Do you have a suggestion for the commission about how you would determine whether the but-for test was objective?
So I don't think that this, at least my understanding of what has been requested to be brought for this commission on remand from the Montana Supreme Court had to do with allocating costs and benefits associated with an upgrade. I don't recall anything in the Montana Supreme Court ruling asking us to define a but-for test.
But this is about refund too, isn't it? Didn't your counsel just say we're talking about refunds?
We are talking about refunds.
Okay.
Actually, we're talking about obligations to fund network upgrades and whether or not, if those upgrades are funded, if there's a refund obligation.
I agree with that. Let me ask you this question. So in your proposal in this case, I don't know how you would exactly describe it. Your position seems to be, if I'm not mischaracterizing, and if I am, please let me know, is that because transmission customers pay for transmission service following the completion of network upgrades or prior to the completion of network upgrades, they are paying, in a sense, for those network upgrades. Is that your position?
No, not exactly. Position is that there's a funding responsibility for the network upgrades and that an interconnection customer must pay for transmission service once. And the upfront funding is to assure that the facilities can be paid for without risk to the rest of the customers. And then as an independent generator takes transmission service, there's a refund on a dollar for dollar basis against those network upgrades that were upfronted as that transmission customer takes transmission service.
And I understand that with respect to independent generators, but Northwestern's generators are not independent, are they?
That's a different pricing mechanism that is applied to retail customers as generation sources are built to serve those customers. And those customers, the retail customers and other OATT customers, actually pay for the revenue requirement associated with all of the transmission facilities on the transmission system, making them a transmission customer.
Right, but your retail customers are the ones who are responsible for paying for the revenue requirement associated, right?
That's correct, which makes them
Right.
the transmission
But
customer.
Northwestern shareholders aren't paying for it, are they?
I'm not understanding the reference to the shareholders.
Okay, here's my point. Make it as clear as I possibly can. You have the CED generators, and as I understand it, the reason they're, in your opinion, not eligible for refund is because in order for them to get a refund, the customers would have to pay for it, retail customers, right?
Can you say that again, please? I'm sorry.
Okay, let me back up. My understanding of Northwestern's position is that the reason that QFs are different than non-QF independent generators is because we're not paying for transmission service. And therefore, we're not in some sense helping Northwestern recover the cost of network upgrades, correct?
It's correct. The funding source for these network upgrades has to come from something.
But my point is that Northwestern's owned generation you serve to use your network retail customers, Western is not paying for that. That's being paid for by retail ratepayers, correct?
That's correct. And as is in the other cases you're citing for non-independent generators, there has to be a source. It's either the retail customers and the other open access transmission customers through the revenue requirement, or in the case of interconnection customers, there is a stream of income revenue associated with the transmission service that they take. They're two separate processes, both equally, they both work for the type of generation that's being interconnected to the system.
I understand that, Mr. Cashel. What I'm saying is the discrimination that's taking place here is not as between independent non-QF generators and QFs, it's as between Northwestern's owned network generators and QFs, because you're not paying the cost of your network upgrades. You're having retail ratepayers pay for it. And the same is true of QFs. The only difference here is under your proposal, QFs don't get refunded.
So there is no discrimination here. Let's be very clear about that. Northwestern's retail customers pay transmission service for all of their service, including for network upgrades associated with generators that Northwestern builds to serve them. It's a very clear process. It's been a process of setting revenue requirements and transmission rates for decades. The independent generator process is fairly new, set by FERC in orders 2003 and 2006 for small generators, large generators in 2003, meant specifically to deal with the network up many things, but in particular to this payment of network upgrades associated with interconnection of independent generators. There are two separate methodologies for payment of transmission service on our systems and recovery of revenue requirement.
Okay, but we are serving, QFs are serving network load just as Northwestern generators are, right?
And there is a requirement under both PURPA law and FERC law that native customers should be indifferent to the costs associated with interconnection of a QF and also for the cost associated
Right,
with.
but there's another requirement in that law, and that is that you not discriminate. Not treat us differently than you treat yourself, right?
With all due respect, we are not discriminating against qualifying facilities. We are following the procedures precisely.
Okay, so we have on one set of network generators that is passing on to ratepayers the costs of their network upgrades. And then we have QFs who are doing the same thing, essentially. They're selling to your network customers. But on the one hand, it's okay that retail ratepayers pay for those interconnections and network upgrades. And then the other, it's not. I don't understand why there's a difference.
There's a complete world of difference. So when Northwestern decides to build a facility to serve its customers, generating facility, there's an entire regulatory process to determine the prudency and the rate recovery of that facility. With regard to a QF, Northwestern has an obligation to take the power of the QF at avoided costs without any control over the siting, the network upgrades that it might incur. It's a completely different process, all laid out by federal law. So it's a valid process. And I think there's valid reasons that there are differences in the way that revenue requirements are recovered, paying for Northwestern's resources interconnection versus a qualifying facilities interconnection or an independent party's interconnection.
But if you, I mean, I understand that you're saying that you've chosen to treat these differently.
No, I
I-
did not say that.
Well, that's what the upshot of your testimony is, isn't it? You're really saying.
I'm sorry, you said that we'd chosen to treat them discriminatorily. We did not
I said differently,
previously. So I apologize for my,
but you are treating them different.
in accordance with the different sets of rules
Okay.
that apply to them.
Where in PURPA does it say that that Northwestern gets to treat its own network generators differently than QFs?
So I'm not a PURPA expert. I am here testifying about the interconnection procedures that apply to independent generators and as we have been applying them to qualifying facilities.
Just a moment, I'm just gonna check.
Thank you, Mr. Uda. Mr. Brown.
No questions. Thank you.
Mr. Brown. All right, commissioners, just procedural matter for the remainder of this hearing. So the order that I'm going to go in for commissioners in terms of questioning, just so you know when your turn is up, I will start with Vice President Fielder, then I will go to Commissioner O'Donnell, then I will go to Commissioner Pinocci, and then I will go to Commissioner Pinocci, Lukacek, and then I will go to myself. So you will know when your time is up, if you will. So Vice President Fielder, do you have any questions?
Mr. President, I don't have any questions for Mr. Cashel at this time.
Thank you. Commissioner O'Donnell,
The same for me, no questions. Thank you.
Commissioner Pinocci, Commissioner Lukacek.
No questions.
All right. Morning, Mr. Cashel.
Good morning, President Brown.
I'm going to start with a basic question. Who at Northwestern Energy is responsible for ensuring compliance with FERC Order 2003?
Ultimately, I am.
And you would also be responsible then for any subsequent clarifications or modifications to FERC Order 2003 then?
Yes.
All right. All right, with that stated. All right, so Mr. Cashel, it's my understanding that Northwestern's allocation method focuses on the benefit of new capacity added to the system through network upgrades, correct?
Yes.
Then why hasn't Northwestern Energy attempted to account for improved reliability, efficiency, resiliency, or competition in its allocation method? Or do you dispute that question?
I don't think I'll dispute it, but I guess I'll offer a clarification that I think that it's inherent in the calculation because what we have done is through system modeling of the system determined from a reliability standpoint where how many megawatts can be added into the system with a particular upgrade. So we look at reliability. That also includes the capacity associated with the facility, but primarily reliability and whatever efficiencies from that, either that one singular upgrade or a set of upgrades that might be determined in the overall modeling process. So I would suggest that collectively, we look at all the benefits that the system might realize through upgrades.
All right, Mr. Cashel, if we find either in this case or in a future case that the network upgrades would produce other system-wide benefits, would Northwestern Energy be able to quantify the value of those system-wide benefits? And if so, how so?
Mr. President, do you have an example that I can attempt to answer?
Say through competition,
I'm sorry.
in promoting competition?
Well, I hadn't thought about promoting competition as an electrical benefit, so I don't know that I can opine today as to what kind of a benefit, how that might translate into allocation.
All right, how about in the area of, say, resiliency?
So resiliency, I think, is easy, easier, because what these upgrades will do is take, in particular with some of the upgrades back to the 100 kV system, the reconductoring would offer resiliency, and certainly the new 230 kV line offers resiliency as well. So while we haven't specifically identified line items of benefit associated with any of that, again, it kind of goes back to the overall system modeling that allows us, in this case, to interconnect something up to 90 megawatts rather than the 75 that's being asked for.
So then I'll ask that of efficiency.
So efficiency, I think about that similar to reliability. I mean, the type of facility that, while we have not designed it completely, obviously, because we haven't gotten that far, we would include up-to-date conductors, for instance, and up-to-date substation equipment that would, by their nature, have more efficiency than older equipment.
All right, back to the FERC order 2003 line of questioning. So you're obviously familiar with the policies and procedures Northwestern follows to comply with FERC order 2003, correct?
Yes.
All right, with that answer being stated, can you describe for me the difference then between an independent transmission provider and a non-independent transmission provider?
Yes, I think the way I would describe that as an independent transmission provider would be like an RTO. SPP, for example, would be an RTO that has, well, let me take that back. An independent transmission provider would have a set of rules associated with interconnection that could be independent from its member transmission providers. So for instance, SPP has a tariff and they have interconnection procedures within their tariff. SPP is a RTO in the Midwest. The the California ISO, has a set of rules under their tariff. Non-independent would be a transmission provider such as Northwestern, which also has distribution and generation resources, but they have an open access transmission tariff in which there's a set of clear rules that must be followed for not only interconnection, but provisions of transmission service.
Is Northwestern Energy, would you categorize it as a vertically integrated utility at this point in time?
With the exception of the fact that there's still some customer choice left in Montana that lingers from previous legislation, we're closer, I would say we're closer to being a vertically integrated utility than we've been for decades.
But Northwestern does own both its transmission system and interconnecting generators, correct?
Yes, that's correct.
How does Northwestern Energy charge non-QF interconnection customers for network upgrades? Can you elucidate that?
For non-QF independent generators,
That's correct.
we follow the processes and procedures associated with FERC Order 2003 and its suborders. And there's three elements of the way the pricing policy works. The first is that the generator, the non-independent non-QF generator, or excuse me, the independent non-QF generator must provide funding for network upgrades upfront. And then as that generator takes transmission service, it's entitled to a refund on a dollar for dollar basis as it takes transmission service. And the other provision, of course, is that native customers and other open access customers they need to be held harmless. So that's why you have the first two provisions. Pay for it up front, and then take transmission service to receive refunds over time, to pay for transmission service in essence one time. But what it does is protect native customers and other OATT customers.
So just for my clarification, a non-independent transmission provider continues to have the option to charge the interconnection customer the higher of an average embedded cost rate or an incremental cost rate for the network upgrade, correct?
That is correct.
And that would be consistent with FERC Order 2003-A.
I don't remember if that's where that appears, but it is consistent with that body 2003 A, B, or C.
So just for my own clarification, Northwestern has two options, correct? An embedded cost or rolled in rate, correct?
That's right.
Or an incremental cost rate.
That's right.
Describe how the rolled in rate works, please.
So the way that we're straying a little bit from interconnection to transmission service. So just a clarification, are we talking about a rolled in rate as it pertains to an interconnection customer, or a rolled in rate as it pertains to a transmission service customer?
Why don't you answer both?
Okay. So a rolled in rate as it pertains to a interconnection customer would be the methodology that we've been talking about, where there's payment up front, and then over time, there are credits that go back. An incremental rate could be, and again, you have to have that relationship of transmission customer in order for this to work. But an incremental rate would be, rather than the rolled in rate that all customers pay, an increased rate over the rolled in rate could be charged to a transmission customer in order to pay for the transmission service over time. And again, not impact customers, the remaining customers on the system. Similarly, a customer taking transmission service, the same phenomena could occur, where if the upgrades that are necessary to serve that customer and calculated against their service exceed our rolled in rate, we have the right to request a transmission customer pay the incremental rate, which is a higher rate. And that also would protect our remaining native customers.
All right, let's address the incremental cost rate then. Describe a little bit about how the incremental cost rate works then.
Okay, I'll use an example. Our current rate for transmission service, and just use easy to remember numbers, $5 per kilowatt month is our rolled in rate. And when we do a calculation, independent calculation, to determine if that $5 per kilowatt month is adequate over a period of time to pay for the upgrades necessary for providing service, that test would show that we could go ahead and charge a rolled in rate. But if the upgrades and the transmission service cost is great enough, there is at some point in time where the calculated rate would be greater than that $5 per kilowatt month. And under those circumstances, the transmission provider does have the right to charge transmission service at that higher incremental rate, in this case, higher than the $5 per kilowatt month, in order to recover the costs of transmission service over time and maintain other customers, hold them harmless. Did I answer your question?
Yes, you did. So just for clarification then, is the incremental rate the same as direct assignment of the network upgrade cost to the interconnection customer?
No, I don't believe it is, because we're talking about payment for taking transmission service as opposed to direct assignment of network upgrades.
So as I understand FERC Order 2003-A, incremental pricing is not the same as direct assignment under that order, correct? If you know.
I don't know for sure how it's characterized there, but pursuant to this discussion, I think that makes sense.
All right, then is there a difference between a direct assignment of cost and an incremental cost rate?
Yes, I think there is, because the incremental cost rate, again, is associated with transmission service as opposed to the interconnection process.
All right, with that discussion stated, then for non-QF generators, how does Northwestern Energy decide whether to charge the interconnection customer a rolled-in rate or, in the alternative, an incremental cost rate?
So this, it hasn't happened often, but from time to time, there have been upgrade costs that are significant associated with a transmission service request. Can you repeat the question? Because I want to make sure I go down the right path here as opposed to interconnection versus transmission.
Sure, I'll restate.
Okay.
So then for non-QF generators, how does Northwestern Energy decide whether to charge the interconnection customer a rolled-in rate or alternatively an incremental cost rate?
Okay, thanks for clarifying, because there's this is important. When it's a non-QF customer, keep in mind that there's two processes. One is the interconnection process and one is the transmission service process. It's in the transmission service process when transmission service is requested by either the interconnection customer or its customer. That's when Northwestern does the mathematics that's necessary to determine if the rolled in rates will be adequate to recover the cost of the transmission upgrades that are necessary to provide the service. So it's at that point in time, it's a calculation that we determine if we have to ask for incremental rates for transmission service or not. It's in my recollection, we've run into this only a couple of times. And in both of the cases, the transmission service that I can recall, the transmission service customers ultimately did not go forward with the service.
All right, when I use the term higher of pricing standard, do you know what I'm referring to?
Yes, I believe that is the same as the incremental cost calculation that we've just been discussing, higher of.
Okay, so then I'm sorry to talk over you. Go ahead.
Higher of versus embedded.
Okay, so what's the point of a higher of pricing standard then?
The same, the point is the same as the discussion we've been having about incremental pricing. The higher of pricing would apply to the situation where you're unable to recover the costs of upgrades necessary to provide transmission service at the embedded rate. So the higher of is elected to go to, or the incremental rate is elected to go to cover those costs.
So let me see if I understand what the higher of pricing standard is designed to do. Is it by allowing a transmission provider to charge a higher of an incremental cost rate or an embedded cost rate? Does that ensure that other transmission customers, including the transmission provider's native load, will not subsidize network upgrades required to interconnect merchant generation?
That's correct.
And that would be consistent with FERC Order 2003-A as well, correct?
That's correct.
Does it also encourage efficient siting decision by the interconnection customer?
I believe it does, and I believe that those words are used in FERC Order 2003.
All right, then if the higher of standard indicates that a rolled-in rate is appropriate, what would you expect the effect would be on all transmission customers then?
Can I ask you to restate? You said if a higher of calculation results in the rolled in rate being appropriate?
Yes, if the higher of standard indicates that a rolled in rate is appropriate, what's the effect on all transmission customers?
All transmission customers are held harmless then.
Okay.
Can I ask you a question on that, President Brown? When you said rolled in, Is rolled in your mind synonymous with embedded rate or rolled in incremental? So what I'm trying to make sure that I answer this properly. I think of rolled in as you can roll in the cost of a transmission service upgrade. And if it doesn't cause upward pressure on your embedded rate, then that's not an incremental rate. That's a rolled in rate that passes the embedded test. Does that help?
Yes, it does. Thank you. Okay. All right, if the higher of standard, I'm going to give you a scenario here. If the higher of standard indicates that a rolled in rate is not appropriate, but Northwestern charged the rolled in rate anyway, what would you expect the effect would be on all transmission customers at that?
Sorry, can you state the question one more time, please?
Sure. If the higher of standard indicates that a rolled in rate is not appropriate, this is just a scenario. The Northwestern charged the rolled in rate anyway, what would you expect the effect on customers would, all transmission customers would be?
I would expect that there'd be subsidization by the rest of the transmission customers.
Would you expect that the average embedded cost transmission rate would also increase for all other customers?
Yes, all else being equal, the next time Northwestern went in for a rate case, there would be increased pressure on the transmission revenue requirement.
Okay, so
Revenue requirement.
all right, then for my understanding and those of my colleagues, help us understand how the higher of standard will apply to a QF.
So again, going back to our position, my position, a QF is not a transmission customer. So the standard of a higher of rate associated with transmission service can't be employed with a QF customer. It's a transmission service process. QF customer is not a transmission service customer.
All right, then I think you responded to a question by Mr. Uda that in your opinion, QFs are not like other generators interconnecting, correct?
That's correct.
All right. Please explain that. What's the difference?
Okay, so excuse me if I've caused confusion here, but my understanding of FERC's higher of pricing applicability is for transmission service. And in providing transmission service, Northwestern can provide service at the embedded rate or a higher of rate if that's necessary to recover the costs of upgrades necessary. In the case of a qualifying facility, we don't have a transmission service customer relationship with a qualifying facility. So the only way for us to recover Northwestern on behalf of its customers to recover transmission interconnection costs is, as we have suggested, to have that interconnection customer upfront the network upgrades to us. And since there is no transmission service relationship with the qualifying facility, there isn't an opportunity for Northwestern to receive transmission revenue and therefore refund the qualifying facilities. So we have a real problem, missing link. The qualifying facility does not have a transmission service relationship with us. So we have to recover the cost of the upgrades in a different way, which is to receive them in funding with no refunds.
So as I understand your testimony, then it's your testimony that QFs do not pay an embedded cost rate for a full transmission system, correct?
That's correct. The QF does not pay for transmission service.
All right, then if a QF's interconnection requires network upgrades and Northwestern rolled in the cost of those network upgrades to the embedded cost rate, what would you expect the effect would be on all transmission customers in that scenario?
In the case that in the scenario where the upgrades are significant and rolling them in would have the effect of increasing the costs for transmission service to the rest of the customers on our system.
Okay, all right, let's go to the other method then. If a QF's interconnection requires network upgrades and Northwestern charged an incremental rate to the QF for those interconnection costs, what would you then expect the effect would be on all transmission customers?
Well, a little bit careful on how I answer this because we don't have that relationship with the qualifying facility to charge transmission service. So, but answering your question directly, if we had the ability to charge an incremental rate to the qualifying facility through transmission service, then the rest of the customers on the transmission system would be held harmless and rates would not go up in general.
So just to sort of underline this line of questioning, which party initially pays for network upgrades?
Under FERC orders 2003 and 2006, the non-QF independent generator initially pays for network upgrades.
Okay, have you read Mr. Schiffman's testimony in this matter?
I've read it. I haven't read it for a little while.
You feel like you're able to answer any questions regarding Mr. Schiffman's testimony?
I think in general I can, and if I need to ask someone to provide me the testimony, then I might do that as well.
Okay, can you provide Mr. Schiffman's rebuttal testimony to the witness, please?
Do you have a particular location in mind, President Brown?
Yes, page 4, Mr. Schiffman's rebuttal testimony. And I appreciate counsel a little bit out of order here, but I think you're sophisticated enough to redress this as part of your various cases in chief and rebuttal questions. On page 4, Mr. Schiffman's testimony, you're there, correct?
Yes, I'm on page 4.
I believe Mr. Schiffman stated that investing more than 80 million to achieve 90 megawatts of incremental capacity is not cost effective, and that a lower voltage solution would likely be adequate to deliver Wheatland's 75 megawatts of capacity. Are you familiar with that testimony?
Yes.
Okay. Based on that, are you familiar with whether or not there are lower voltage solutions available for CED Wheatland's network upgrades?
There are really not. And if I can use an analogy, that might help.
Please proceed.
Okay, so the area that we're talking about here has a 230 kV line that runs from Broadview up to Great Falls. And this project is intended to interconnect between Broadview and Great Falls. Along with that transmission system, we have a number of 100 kV lines that run in parallel to that. And in using the analogy that Ms. Norcott started with, you can think of the 230 kV line as being the larger pipe, call it the 4-inch pipe in this scenario. And then the 100 kV lines that are running in parallel are the smaller 2-inch pipes. So what happens in the contingencies that cause the problem is the loss of the 230 kV line from the project's point of interconnection up to Great Falls. And when that line is lost under planning scenarios, what can happen under stress conditions is the underlying 100 kV system can overload, causing voltage collapse in the area. So adding another 100 kV line in that series of parallel lines doesn't solve the problem. Major problem is the loss of that 230 kV line, that larger pipe. that under stressed conditions is critical to the operation of the system. So it's our engineering position and view that a smaller interconnected facility cannot provide the needed reliability for this facility.
Okay, along that lines, then what is, generally speaking, what is more expensive, a lower voltage line or a higher voltage line?
Well, generally speaking, the higher voltage line is going to be more expensive. Certainly in the engineering and design, right of way may be just as expensive no matter what your facility you're talking about, but generally a higher voltage line will be more expensive.
Okay, you talked a little bit in your response to my previous question. So about how Northwestern Energy determines whether a transmission project is cost effective, correct?
Yes.
Okay. So in the context of transmission planning and development, describe to me what factors Northwestern Energy uses or considers when determining whether a transmission project is, quote, cost effective.
First of all, we need to look at the problem they're trying to solve. And in this particular area, thinking about the problem we now face, we have a situation where we have relatively small amounts of load served off of that 100 kV system. And we've got the major highway, if you will, the 230 kV line that connects Billings and Great Falls to serve greater load. Without the generation that's been added to the system, there really isn't a need to do much in the way of the transmission system through this path we call south of Great Falls, which is kind of everything running south of the interconnections between Great Falls and Billings and Great Falls and Helen and Butte. But what we have experienced recently in the last 10 years or so is the generation that has connected to our system and is attempting to connect to the system is using up the latent capacity in our transmission system. So now we're faced with what do we do going forward in order to maintain reliability. And the way the interconnection process works, the cost causer is looked to for upgrading the system with regard to interconnection of their generation interconnection facilities. At some point in time, these issues are going to blend. And we're going to be forced to make upgrades that solve both problems, both generation interconnection and load service. But there are very discrete funding mechanisms within federal interconnection law that we point to help us to identify the upgrades are necessary and the funding mechanisms to meet the interconnection needs of customers and also keep our other customers held harmless during that interconnection process. So we have a blending of processes going on here, President Brown, where it's both generation interconnection and concerns about serving local area load that are going to be colliding.
So what I'm hearing from your testimony is that there are factors beyond just mere line costs that Northwestern Energy takes into consideration when choosing between a high voltage solution and a low voltage solution, correct?
Absolutely. And if I got off on a different tangent, I apologize, but you're absolutely right. There's siting considerations. There's what type of load or generation is going to be served, all kinds of things.
Okay, then back to the line cost question. Is it Northwestern Energy's position in this matter that the 230 kV line is the most cost-effective line for interconnection with CED Wheatland?
In order to solve the problem we're facing, yes, we believe this is the right solution.
How did you make that determination? What factors went into that?
So I'd encourage you to ask questions of witness Tom Pankratz as well on this, but just in general, the way we made the determination was through planning studies and loss of load and contingencies, and determining with the contingencies studied. And again, I described the major contingency was the loss of the 230 kV line between the point of interconnection and Great Falls. What was the result of that? The result was overloads of an existing smaller 100 kV system. And to effectively mitigate for that, an additional 230 kV line segment was selected between point of interconnection and Broadview.
Certainly one of the issues that I think that has been raised in this matter is whether or not Northwestern could go to a lower voltage solution, correct? You're familiar with that?
Yes, that issue has been raised.
So why isn't Northwestern proposing a lower voltage solution?
Okay, going back to comments from a previous set of questions, the reason we're not proposing a lower voltage solution is because we don't believe it solves the problem. Again, the major problem is the loss of the 230 kV line, that large pipe. And the loss of the large pipe overloads the 100 kV system. And that would still be true if there was another 100 kV line that was built for mitigation here. The problem with that is it would not be sufficient to maintain system reliability.
Okay, so you're certainly familiar, I think, that there are several commissioners here who have an interest in the benefits that could be afforded by advanced conductors, correct?
Yes.
So to that end, has Northwestern considered reconductoring the existing line with higher capacity advanced conductors?
So we always consider whether or not an advanced conductor would make sense in an application. In this particular case, however, if we were to use a higher advanced conductor, high efficiency, higher capacity advanced conductor, it would be additional cost in this case, and we wouldn't realize. I'll make it clear. We could make that solution. We could make that selection. But in this case, it would not provide us with any additional usable, reliable capacity until we were to go to the next contingent facility and upgrade that contingent facility. And in this case, that next facility is a big facility. It happens to be our 100 kV line that runs from 2 back to Crooked Falls, the Great Falls area. It's about 125 miles, something on that order. And we have reconductored about 25 miles of that line in the middle of it, between Monarch and Kings Hill, roughly, with high efficiency, higher capacity facilities. But still, that's the next contingent facility. So if we were to build the 230 kV line we've been speaking of with this higher contingent or higher capacity, high efficiency conductor, we wouldn't be able to realize the benefit of that until we then went in and rebuilt the line from 2 to Crooked Falls so that we could eliminate that contingency. So just generally speaking, it's a complex transmission system, and adding one piece of transmission line at a higher capacity, higher efficiency doesn't necessarily gain you that capacity right away until you then take care of other parts of the transmission system.
Right. In your opinion, what is the lowest voltage line that Northwestern Energy could install to move CED Wheatland's energy to the Broadview substation?
My opinion is it's the solution we've come up with, which is the line segment, the 230 kV line segment, and the point of interconnection back to Broadview.
As a matter of transmission planning, and you can let me know if you're not the right witness for this question, but do you believe it is prudent to expand the transmission system with sole use facilities or facilities that are tailored to provide only the bare minimum of new capacity needed for each additional generator?
I can opine on that, but I would ask or suggest that maybe asking Tom about this as well. But my view on overall, we have to be planning for the future and be willing and able to make upgrades to the system that anticipate future needs. And we're actually in this area because of the generation interconnection. If CED doesn't pay for this upgrade, then we will likely have to make this upgrade. And those costs will fall to our customers, the rest of our customers, because we're at that point on our system that with either future growth, reliably serving the growth, kind of the organic growth that we may see in that area, and all the generation that's coming on, we are going to have to make this investment. It's really a matter of who pays for it.
Right, you mentioned Mr. Pancratz. Did you review Mr. Pankratz's testimony prior to this proceeding?
Yes, I did.
You're familiar with it generally?
Generally, yes.
Could you provide your witness, Mr. Pankratz's rebuttal testimony, please? Turn to pages 9 and 10 of that testimony, if you would, please.
Okay.
On pages 9 and 10 of Mr. Pankratz's rebuttal testimony, Mr. Pankratz describes the hiring of an independent third party to review Northwestern System Impact Study known as an SIS. Are you familiar with an SIS?
Yes, I am.
And Mr. Pankratz also testifies about the hiring of the SIS to replicate and verify the results. Are you familiar with that testimony, correct?
Familiar with the testimony and the process.
Okay. So was that third-party review required under any of Northwestern Energy's existing interconnection agreements or policies, to your knowledge?
So we undertook that third-party review in an attempt to resolve the ongoing dispute with CED.
Not sure that answered my question.
So what I can be more specific. We agreed to an interconnection dispute process under our interconnection processes with CED in order to try to resolve the outstanding concerns that we had and they have.
But there was no such requirement in any existing interconnection agreement or policy, as I understand it.
So I guess I would say that they're in the interconnection procedures, both small and large interconnection procedures. And this is a large interconnection process. There are processes outlined within the interconnection procedures to dispute processes for dispute resolution. And we followed those processes.
Okay, that was responsive to my question. Thank you. How was the independent third party selected? Describe the process.
So trying to recollect, Northwestern reached out. Sorry.
I'm sorry. Go ahead.
So Northwestern, in thinking about the process, we had the opportunity to reach out to an independent party, actually. And then we proposed that party to CED for a third party that could be acceptable to both parties to try to resolve the dispute.
Are you familiar with what materials the third party considered when analyzing the SIS? Would you have an understanding of that?
So the third party was provided with all of the applicable interconnection studies, models. Third party, like any party in the industry, can request base case models from WEC, the Western Electricity Coordinating Council. And then that third party was able to run interconnection studies and test the results of the system impact studies, given that person's understanding of the industry, and by requesting information from both us and also requesting information from CED.
All right. So as I understand your testimony, the third party was provided materials by CED.
Yes, and again, I encourage you to ask Mr. Pankratz these questions too, but the third party had the opportunity to request information from both Northwestern and CED As I recall it, the third party had independent discussions with Northwestern and CED as part of his review. And then produced a report an independent report that both CED and Northwestern were able to look at, ask questions. I think there was 1 or 2 iterations in his report.
All right. How long did that third party review process take? Do you recall?
From start to finish, I couldn't tell you exactly how long, but it was over a course of months, several months at least.
And was Northwestern Energy satisfied with the results of that review process? That's a general question I appreciate.
So I would say generally, I think the process worked well for, from our perspective, to assure that we had conducted the studies properly. I think there was 10 elements that were reviewed, and for the most part, in my view, most part, the third-party analysis determined that what Northwestern had done was proper.
So the third party, as I understand it, produced a written report of findings and analysis on the same, correct?
That's correct.
Do you know if a copy of that third party report is in the record in this matter at this time?
Don't know offhand. Maybe I'd ask my attorney, Ms. Norcott.
All right. That is the correct answer. All right. For someone who made the admonition to keep this hearing short, my questioning went a bit long today. Mr. Hamilton, do you have any questions?
Thank you, Mr. President. Just one for clarification. Earlier on in your testimony or in the examination, Mr. Cashel, you mentioned or discussed the term participant funding. Could you describe for me what participant funding is?
Can you remind me where I might have said participant funding? I don't remember that specifically, but
Yeah.
what was the context of the discussion?
I believe it was during the cross-examination with Mr. Uda. He referred to passages of FERC Order 2003 and its discussion of the participant funding or participant financing.
Okay. And then your question once again, please.
Yeah, could you describe for me what that term means to you?
Well, to me, I may not have used a proper word, but the participant funding question you asked has to do with in the interconnection process, the interconnecting generator is required to provide upfront funding, participant funding, to pay for the interconnection costs, the network integration, the network upgrade costs. And the reason it's required to do that is to provide a quick funding mechanism so that the project isn't held up from the interconnection party standpoint. And then, of course, the procedures go on to talk about how that funding, in the case of a non-QF generator, is ultimately refunded to that non-QF generator.
So is it fair to say that the concept of participant funding is an aspect of the interconnection customer relationship, whereas the higher of analysis that you were discussing with President Brown earlier is a feature of the network service customer relationship?
Yes, you said that much better than I did during the discussion. Absolutely. The upfront funding is a interconnection process, and the higher of methodology is part of the transmission service process.
So when FERC is referring to the problems associated with participant funding for a transmission service provider that is not independent, it's concerned. Can you describe for me what FERC's concern is there?
So I don't have that in front of me, but Mr. Uda's line of questioning was suggesting that the non-independent transmission provider could be incented to put up roadblocks, if you will, to an independent generator. Is that what you're getting at?
Yes, Mr. Cashel, I believe that answers my question. I'm sure if it needs further clarification, the parties will handle that. I'd like to move on to one more point of clarification. I believe you mentioned earlier in your responses to President Brown's questions that Northwestern, as part of its allocation method here, did not attempt to line item
the benefits associated with factors like increased resiliency or increased efficiency of the transmission system. Did I understand that correct?
That's correct.
What I'm trying to understand, Mr. Cashel, is why? Why was that not included as part of the allocation analysis?
That's a good question. The allocation process was really intended to determine the capacity benefit associated with the upgrades and how to allocate that capacity benefit. And as I testified earlier with President Brown, there may be, if there are other benefits, they would have been captured in our modeling. But I think they'd all be rolled up into how much capacity was available for potential service to another customer. The fact that we didn't line item by line item look for specific reliability or efficiency benefits, it just didn't occur to us that that was potentially something we ought to look at in the allocation. Perhaps Mr. Pankratz could speak to this, but I do believe that the overriding benefit, the largest benefit associated with the additional capacity would be that identification of the capacity. Other benefits would be kind of embedded within that.
If Northwestern received direction from the commission to try to put a dollar value on the benefits of resiliency, efficiency, increased competition, is it possible for Northwestern to do that?
I think we could look at that, given direction like that. I don't know how successful we'd be in coming up with something like that, but I think if we were given that direction, we would do it.
Nothing further, Mr. President.
Okay, for everybody here, we have been going for about an hour and a half, and I've been asked to do a quick break. I think once we return from break, what we'll do is finish with this witness and then just go into lunch at that point in time. So the time is now 11:24 a.m. and we will take a 5-minute recess, 6-minute recess. We'll reconvene at 11:30 a.m. Time is now 11:32 a.m. We will go back on the record where we left off with Mr. Cashel was you cross.
Yeah, I have just a few questions that were prompted by your questioning.
All right, please proceed, Mr. Uda.
Mr. Cashel, Chairman Brown asked you some questions about the arbitration study that was conducted for Wheatland Win. Do you recall those questions?
The third party review.
Well, it was an arbitration, is my understanding.
Yeah,
Binding arbitration.
I do recall those questions.
Okay. Is the arbitrator studying this study? One that the load flow study, for example, that you're. Oh, I'm sorry. Sure. So was the arbitrator examining Northwestern's testimony exhibits, essentially their load flow study and results that Northwestern has presented in this proceeding? Or was he doing the prior iteration?
Good question. And I don't think the results changed my testimony at all. But there was a restudy done of the, to your point, Mr. Uda, a restudy done. And that restudy was in part a result of the third party review process, not totally, but in part. There was also a change in interconnection queue.
But when the arbitrator was issuing his report, he was examining the prior proposal to build the entire 230 kV line, correct?
I believe that's correct, yes.
And after the arbitration study recommendation result, hold on, this questions. Did the arbitration study recommendations result in Northwestern restudying the Wheatland interconnection?
As I, excuse me, as I just said, I think in part, I think there was also a queue change, but there was a interconnection, another study of the entire area, which included restudy of the Wheatland interconnection. And the result there, just for the rest of for the commission, was that the decision then, to your point, President Brown, about is there a better solution or a different solution? The restudy actually.
Mr. Chairman, I'm going to have to object. The witness is going well.
Sustained.
Sorry.
Well, I think it's important, but.
Well, your lawyer can always ask you on redirect. After the restudy, did the arbitrator recommend network upgrade charges for a 230 kV line from Broadview to Great Falls to a 230 kV line just from Wheatland to Broadview?
I'm sorry, can you restate the question?
Right. So the question is that, as I think we've discussed, the original proposal was a 230 kV line from Broadview to Great Falls, correct?
That's correct.
So did he recommend a 230 kV line just from Wheatland to Broadview?
So I don't remember if that was his recommendation or if as a result of the restudy effort, that's the solution we came up with. But ultimately it was a shorter line and is contained in the second study.
Okay. Did the arbitration report result in Northwestern changing its generation injections to result in reduced flows in the southbound direction?
So I think for the direct changes to the study, that's a question for Mr. Pankratz.
I'm just going to examine my notes for a minute. I don't think I have much else. As an engineering matter, can a 67 kilovolt line carry 75 megawatts of generation?
depends totally upon the system that that line is integrated into.
But all things being equal, the answer is yes, correct?
I don't agree with that.
So would you agree with me that Northwestern's proposed network upgrades and so on are dictated by the low flow studies prepared by Northwestern, specifically Mr. Pankratz?
Can you state that question one more time?
Sure. You performed load flow studies, determine the necessity for this particular set of network upgrades, correct?
One of our planning engineers would have performed those studies. They're not just load flow, but dynamic studies as well.
But you didn't do those studies.
That's correct. I did not do those studies.
On the efficient siting question, is the only factor that goes into whether a potential generator decides to locate at a particular site entirely the issue of network upgrades?
I'm not a developer, so I'm sure there's lots of decisions that have to be made, but from a developer, but from a transmission provider's perspective, the amount of network upgrades at any location is really what we're talking about here, and that's what FERC Order 2003 was talking about.
Might it be for a wind developer, the wind regime, how good a wind resource they have in that particular location?
Well, sure, I agree with that, but from a transmission perspective, it may not be the best location to interconnect because large transmission investments and upgrades may be necessary. That's just the competing interest we have here.
Could it also be the availability of
Again, it certainly could be. But from a network standpoint, that's how we got to a point where these network upgrades are so large, is because the transmission system in that area, which might have other good attributes, the transmission system is not all that robust. It's not designed to do what it's being asked to do today.
But if you're from a developer's perspective, you have to take all those things into account.
Certainly.
Thank you, Mr. Huda. Mr. Brown?
Just one line of questioning. Thank you, Mr. Chairman. Mr. Cashel, you had mentioned that it wasn't so much a question of whether these upgrades would happen, but rather who would pay for them. Do you recall that?
I do.
And so if CED does not proceed with its project and does not fund these upgrades, would you expect other developers of generation projects in that on that part of the system to be the ones who pay at least in part for these upgrades?
I do. If requests to interconnect continue to come, someone in that interconnection process will end up paying for these upgrades.
Thank you. That's all I have.
Or just one last thing, depending on this allocation process, it may end up being that Northwestern customers, other customers end up paying at least in part for these upgrades.
Mr. Chairman, follow up.
Yes, of course.
Can you explain that a little more in terms of why it would fall to Northwestern retail customers as opposed to other developers of other generation projects?
Sure. Actually, my testimony does go into this a little bit, but the request from the Supreme Court suggested that there may be benefits for others. So it directed us to come up with some kind of process. Our allocation process seeks to find the cost causers. But there is a scenario out there where if CED pays for a portion of the upgrades, albeit a large portion, 83%, there's still 17% of the cost left. And if another generator doesn't step up into the process and pay for a portion of those upgrades, either another QF or a generator under the FERC process, Northwestern retail customers could end up being the default payer if no one else actually does come in after CED.
Great. Thank you, Mr. Chairman.
Ms. Marcotte?
Thank you, Mr. Chairman. Mr. Cashel, in questioning from the chairman and also Mr. Hamilton, there was a discussion about benefits to the system as a whole. Do you recall those conversations?
I do.
Overall, looking at just these network upgrades, are there system-wide benefits to the transmission system?
Not necessarily. There's system local area upgrade benefits to that area. But I'll use the example of the Missoula area, Western Montana. These upgrades probably don't do anything at all to improve the service in Western Montana.
Okay. So is there a chance that it improves service in that general location where those network upgrades are being completed?
Yes, and as we have described in this process, up until the next limiting factor, there are some benefits that would be derived from these network upgrades.
And I believe you talked about in your testimony that this particular area is a low load area on Northwestern system. Was that correct?
Yes, so the system is really designed in a couple of different ways there. The 230 kV system helps us to move energy around the state from more populated area to more populated area. The 100 kV system and the lower voltages below that run parallel and in that area are primarily, not in total, but primarily load serving and serve more of the rural areas associated with that particular part of the state.
Northwestern is transmission constrained generally, correct?
Yes, many areas of our system are becoming strained due to load growth, generation interconnection. Yes.
Okay. How about capacity? Is that a concern, having sufficient capacity?
Are you talking about transmission capacity?
Sorry, transmission capacity.
Yes, I view being constrained and having enough capacity as similar. And either one of those can lead to non-reliable situations.
So do these network upgrades that are needed for the Wheatland project add any value to Northwestern's capacity situation for transmission capacity, to be clear?
In other areas of the state,
Yes.
no. It adds a little bit of capacity in that general area up until, again, the next potential overload. But as testified, there's about 15 megawatts of additional capacity in that general area.
If it wasn't for the Wheatland project, would Northwestern had made these system upgrades to its system?
So just thinking about our interconnection queue, there are projects ahead of Wheatland and there are projects behind Wheatland. Some of those projects are clearly moving forward and using latent capacity and some aren't. So at some point in time, in order to serve this whole slew of potential interconnection parties, we may have to make upgrades. But to serve the load in local area, we would not be facing these kind of upgrades.
Is Northwestern specifically looking at building generation in this area?
Generation in this area?
Correct.
Not that I'm aware of.
There was a conversation about, well, there was a lot of discussion this morning about the difference between the interconnection process and the transmission service process and the rates and how those costs get assigned to the customer. Just to take a step back for a minute, Are the network upgrades that Northwestern has identified for the Wheatland process necessary for its interconnected operations?
For Wheatland's interconnected operations?
Correct.
Yes.
There was also some discussion about is there an alternative solution to the 230 kV line? Do you understand, or what is your understanding of this case as far as what is before the commission based on the Montana Supreme Court's decision?
My understanding is what's before the commission is the allocation of the costs for the network upgrades that have been selected.
Where is CED interconnecting?
I
Yes.
don't know exactly where CED is interconnecting. Are you talking about Wheatland?
I'm sorry, yes, sorry, Wheatland. Where are they interconnecting? What point on the transmission system?
I'd have to go back and take a look at, I can't remember exactly where they're interconnecting.
Are they interconnecting to a 230 kV line?
I can't remember exactly where they're interconnecting.
This CED has the option to interconnect anywhere on Northwestern system.
They have the option to request to interconnect anywhere on the system. And they've made that selection in their processes.
Is it possible for CED to build its own transmission line to a different point of interconnection on Northwestern system and ask for interconnection at that alternative point?
It could. We've had developers do that.
Going back to this 230 kV line and Mr. Brown's questioning about, these upgrades may need to be made no matter what. Are there QFs behind CED that also require these upgrades?
So I can't specifically,
Mr. Chairman, can I ask a question of clarification? I'm not entirely sure what the question is posed. Are you saying that there are people who are
Yeah.
in the interconnection queue?
Correct.
and my answer was going to be, there are certainly junior queued projects, whether they're QFs or independent generators. I couldn't specifically specify each, but I think there are both qualifying facility and independent generators in the queue for and after CED.
And I believe you testified a few minutes ago that Northwestern is not looking to install or build generation in this area that would require these upgrades. But assuming that Northwestern was, do you believe that Northwestern could justify these network upgrades at this particular location for a project to the commission that results in just and reasonable rates to customers?
Objection, compound question, and cost of speculation by the witness.
I'm going to sustain that. Could you just break down the questions better? Thank you.
Thank you, President Brown. I didn't catch all the questions there either.
Noted. Northwestern's not looking to build generation in this area, correct?
Not that I'm aware of.
Could Northwestern, if it was looking to build generation in this area, justify a project that required these network upgrades to the commission?
This goes to one of the points I made earlier, and that is that there are separate processes for Northwestern to get not only transmission rate recovery, but also generation rate recovery. And the prudency of that would be recovering those costs would be part of a contested case process, and you have to be able to make a showing that it was a least cost proposal and stood up to other options.
And finally, some questions for you about the third-party study that was conducted. You were asked some questions by Mr. Uda on recross related to the results, and you were going to expand. Can you please now expand what you were going to say earlier?
Sure. So what I wanted to expand on for the purposes of the commission was that the result of the restudy effort, which again, my recollection was in part from the third-party evaluation and also Q change. Northwestern recognized an error in the study and we fixed that. And because of that, there was, to Mr. Uda's point, there was less generation that was assumed to be in the queue. But the outcome was a really good outcome. It resulted in us determining that we could make smaller upgrades to the system, about half the 230 kV line that we had proposed before, and had significantly less upgrades associated with it. So in my view, it was a success from that standpoint because the upgrades that are now before CED in terms of cost and also the magnitude of the upgrades are less. And that in my mind was a positive outcome of the process.
Mr. Chairman, may I approach?
Go ahead and approach.
Mr. Cashel, can you identify what I just handed to you?
Mr. Chairman, regardless of whether he can identify it or not, this was not identified by any party to this proceeding. Hearing memorandum of exhibits. That would allow us to have notice to be prepared. I don't know that it's going to be, but I just have to object on the grounds that this should have been disclosed if they wanted to use.
Go ahead.
Mr. Chairman, I thought there would be value. I did not identify it in our pre-hearing memo because we did not intend to move it as an exhibit. However, the commission had substantial questions about it, and I thought there would be value to the commission to have it in the record as part of this case, given the discussion today or this morning about Mr. Angel's report.
Might just be heard on this. This is studying the proposal, studying the old 130 kV line at least in its proposed form. The Supreme Court said it's discriminatory under perpetuity amount of cost. So I don't know that this has particular relevance to this proceeding, and also it should have been.
Mr. Chairman, if I may.
Of course.
Mr. Uda, I'm surprised to hear he doesn't think it has relevance to this proceeding, given his own expert cites to this report in his testimony. Again, it wasn't identified in our pre-hearing memo because it wasn't something we planned to introduce as evidence, but given the commission's questions, see that there is value in having the full report.
Indulgence, she can ask about the portions of this that she can ask by laying a foundation for production. Right now, she's attempting to essentially on hours and 45 minutes into a hearing by any party.
So I think Mr. Uda has laid the proper path as to how we'll deal with this document. For now, please just set it aside and we'll take it up later in the hearing.
Very
Thank
good.
you.
With that, Mr. Chairman, I have no further questions.
All right. Would you like to temporarily excuse this witness?
Yes, thank you.
All right. You're excused. Thank you,
Thanks,
Mr.
President
Cashel. The time is now 11:57 a.m. This would be a good time to break, I believe, for lunch. So why don't we reconvene at 1 o'clock sharp to resume today's hearing? And with that stated, we will go off the record at this time and resume at 1 p.m. sharp.